Shall we go? Maria?
Yes.
Yes. Okay. Hello. Good afternoon, everyone, and welcome to this event that we have organized on the EU-UK TCA agreement. It's, of course, always timely to talk about this, but it's been a year since, more than a year that since the agreement entered into force. And of course, discussions about Brexit opportunities and making the most of Brexit opportunities are very much alive. And we couldn't help it but join this conversation from, in particular, a trade union perspective. So we are very pleased to host this event that is primarily focused on reports produced by Professor Ortino for TUC, and that you can find on the event page that contains the ETUI agenda. There's been a slight change on with that agenda. I will pause in a few seconds and pass the microphone to Professor Keith Ewing, who will introduce the report by Professor Ortino and frame it within the Brexit agreement. Then Professor Ortino will present his report. Unfortunately, the Confederal Secretary and Deputy General Secretary of ETUC, Class Michael Stahl, cannot join us. He will be replaced by Daniele Basso, who's eminently qualified because he's been working as an advisor on Brexit matters for a few years now. Daniele, thank you for joining us. And MEP Ben Lang, who's also joining us, will have to dash to another meeting. So you will have an opportunity to ask a few questions through the Q&A facility on the Zoom screen to him directly as part of this session rather than in the next session. Everything else remains unchanged, and it's my real pleasure to welcome to this event Professor Novitz, that will also be involved in the second part of our conversation after the break, and of course Rosa Crawford, who has been working on this issue on behalf of the TUC and has also had a leading role in organizing the works around the report by Professor Ortino and contributed greatly to this event. This event will benefit from simultaneous interpretation. You can just click on the little globe, and I think everything else is very much as originally planned. So, Professor Ewing, Keith, the floor is yours. Thank you.
Okay, okay, thanks very much, Nicola. I'm really sorry I can't be here for the whole session, but I'm really pleased to have the opportunity to welcome or to introduce the report, which I think is a fantastic and very important document at a time when I think it is very much needed. It sets out the core issues very clearly. It helps to raise awareness about the issues, which is especially needed at the present time. And I think it helps us explore some of the different ways by which we can give effect to the obligations which are set out in what is a very long and detailed document in terms of the TCA. But what I wanted to do is just really to look at some of the substantive provisions of the agreement so far as it affects workers' rights, and really just to highlight three provisions which hopefully we can deal with in the course of the discussion. And the first of these is Article 386, which is, I think, the non-regression provision in terms of labour rights. I think it lists there 5 different general issues relating to labour rights, designed, I think, to prevent a regression of labour standards in order to secure some trade or investment advantage. And I think probably set at a level which existed at the time of Brexit in terms of, I think, indirectly giving effect to the European social model as it then operated at the time, and in fairly general terms, with a bit of additional stuff added in. And I think the effect of this, we don't really know how effective this is going to be in the UK. I think the government at the moment, I believe, is getting ready with a freedoms bill, which is going to help us to secure those elusive freedoms which will arrive as a result of Brexit. And I think part of that, well, the question is whether part of that process will include a deregulation of some of the European social model in a way which would bring us into conflict with Article 386. But I guess, given the nature of the government that we have here, we won't know whether it will cover labour rights, and we won't know to what extent it will compromise 386 until we see the ink on the page on the final piece of legislation as it gets the royal assent. So anything, I think at the moment, anything could happen in a way which would affect the provisions of 386. But that apart, I think the other points, I think, which is worth highlighting is Article 399, paragraph 2. And I think this is important for us, particularly in the UK, I think, which imposes an obligation on the parties to the agreement to respect, promote, and it uses the term effectively implement core labour standards as these are informed by ILO conventions. And that would include, of course, conventions 87 and 98, as well as the other 6 core conventions which deal with the other 3 fundamental principles. And that, I think, I'll say in a minute why I think that's significant. But the third provision from a labour perspective, I think, which is important, is Article 399, paragraph 5, which I should emphasise, which, like paragraph 2, is not linked to trade or investment. So my understanding is that these are freestanding obligations unrelated to trade or investment. I think that's important as well. So 3992 deals with core labour standards. 3995 is much wider in the sense that it imposes a duty to implement all ILO conventions, which we have ratified, as well as the provisions of the Social Charter, the European Social Charter, Council of Europe Social Charter, the provisions of which we have accepted. And so I understand, remember, I think from memory, we've accepted 60 of the 72 different provisions of the original Charter of 1961, which in a sense puts us, I think, in the second division within the Council of Europe in terms of the number of obligations accepted. But nevertheless, there is an impressive list of obligations there that we are required to comply with. So these, looking at this as a labour lawyer, not as a trade lawyer, but looking to a trade lawyer to help me as a labour lawyer, I can see there are 3 different provisions. One in 386, which is related to trade and investment. 2 in 399.2, which is not related to trade and investment or investment. And the other in 399, which is very, very wide, 399.5, which again, not related to trade or investment, which deals with all ratified ILO conventions and all accepted provisions of the Social Charter. Now, why these are important, why 399.5 in particular, well, 399.2 is important. And the reason why this is important, I hope in the sense that our European colleagues are fully aware of some of the problems that we have in this country. And if you look at freedom of association in particular, and conventions 87 and 98 in particular, I think it would be true to say that of all the leading European countries, democracies, the United Kingdom has the tightest legal restrictions on freedom of association. and has had really since 1989. So we've been complaining on a regular basis to the ILO about 87 and 98, regularly since 1989, and just as regularly the ILO Committee of Experts has been informing the United Kingdom government that yes, indeed, what you have done and what you're proposing to do does or will violate these ratifying these obligations which the United Kingdom has accepted. Another point, again, for the benefits of European colleagues, is that on Convention 98 and the duty to promote collective bargaining, the United Kingdom, one of the biggest countries in Western Europe, but it has one of the lowest levels of collective bargaining density anywhere in Europe. And we would be severely embarrassed were we still in membership of the EU, faced with an obligation to implement the proposed directive on minimum wages and the commitment to get anywhere near something like a 70% collective bargaining density. We are looking at collective bargaining density levels, which are now barely above 30%, if they're even at that level. And the likelihood is that they are falling. There's very little sense that collective bargaining density is in any way improving. So that's one issue. The other point I think which is relevant to the report we're discussing is on 399.5, the duty to implement all ILO conventions that we have ratified. And again, I did a review over the last 10 years of Committee of Experts examination of fairly random conventions. And there were 7 conventions which over the last 10 years, in addition to freedom of association, we've been found to be in breach of. And these include things like the accidents at work, related to accidents at work, the fact that people who are injured at work in the United Kingdom are required to pay for any drugs or medicines that they need as a result of their industrial injury. We've got criticisms relating to Labour Inspectorate Convention because of the failure of the British government probably to finance or to fund the Labour Inspection Service, which is in a pretty poor shape as the pandemic revealed. And we've got excoriating criticism of the United Kingdom in relation to the Social Security Minimum Standards Convention by the Committee of Experts, which expressed the view that the standards in the United Kingdom are so low that the levels are so inadequate that they threaten the very survival of the European standards. I mean, it's extraordinary. The criticism of the committee in that case is probably among the strongest I've seen in any international supervisory body in relation to any social legislation. So there's that. And then finally, there is on the Social Charter of 1961, I mean, we quite haven't yet got around to ratifying the 1996 version of it, but even the 1961 Charter, last time we were subject to scrutiny or investigation by the Social Rights Committee. They looked at 13 labour rights in 2019, 13 labour rights that we had accepted. We were found to be in breach of 10. So in a sense, 10 out of 13 we're failing to comply with. This isn't new. This has been going on for year after year after year. And it includes, of course, Articles 5 on the right to organise and Article 6.2, collective bargaining, 6.4 on the right to strike. So in a sense, I mean, it just all adds, grist to the mill that we are serial violators of standards which are now included in the TCA, which we are required by the TCA to implement, standards under ILO core labour standards, other ILO standards, as well as the provisions of the Social Charter. And my pitch, I think, really is, I mean, you just reached a stage, having worked on this for so many years, a stage of complete exasperation, in the sense that there is a fundamental rule of law question here, which I think at some point we're going to have to accept and acknowledge. And I think the point for me is that the European Commission has, quite recently woken up to the fact that the rule of law is an issue, despite the fact that it's all over the treaties. It's included in the TCA as well as a principle. But the rule of law is not just about judicial independence in Hungary and Poland, although these are clearly important questions. It's not just about compliance with the Northern Ireland Protocol. It's also about ensuring that parties to these international treaties actually comply with the obligations they make. And there is a responsibility on everyone's part, both the United Kingdom and the European Commission, to ensure that both sides fully comply with these undertakings. And that is why I think Federico's report is so important, because it actually highlights the ways by which some of these provisions can be implemented and enforced. And we need to listen to this, take it seriously, but above all, we need to do something about it. I mean, this isn't a paper exercise. We can't be crossing our fingers and hoping that maybe the United Kingdom will someday return to the European Union. For the foreseeable future, that is not likely. For the foreseeable future, we've got to make this work and make the most of what is there. We've got to start talking about it, campaigning on the basis of it, and seeking to enforce what is currently on the table before us. Thank you very much.
Thank you very much, Keith, for providing us this extremely insightful context for Federico to present his report. Federico is a trade law specialist. He's a professor of law at King's College, London. Federico, the floor is yours. Thank you very much. Thank you.
Thank you, Nicola. And thank you everyone for the invitation, and Keith for the introduction. I think it sets out the broader context. I mean, I'll try to, and the purpose of the report, as I've stated also expressly in there, it is exactly to try to describe and explain both the substantive protections that the TCA includes when it comes to social and labor rights, but as well as to explain the mechanisms, the implementation and enforcement mechanism that are included therein. Now, showing sort of strengths and weaknesses of what we have in front of us. And also at the end, the report tries to at least suggest options that should be considered in the sense of trying to strengthen the TCU in view of the upcoming review of the TCA that should take place 5 years after its entry into force, so in 2026. Now, in terms of the substance, I've tried to, what I did, I started out by setting out the objectives of that you find spelled out in the TCA. When it comes to, I mean, more generally, the level playing field chapter, but also the labor obligation sections. And it's important to underline this, even the heading of the chapter focuses, yes, on the need to ensure the level playing field for open and fair competition between the parties. But crucially, it's also there to ensure that trade and investment takes place in a manner conducive to sustainable development. I think the overall objective is important, as we will see when we get to trying to interpret some of the provisions there. Now, I'm not going to go through the entire report, but perhaps I will sort of highlight some of the novel features of the report, at least compared to what has been the practice in trade agreement terms of both the EU and the UK more recently. So when it comes to the substantive obligations, as Keith mentioned, the non-regression clause is there, as has been in most FTAs dealing with labor rights. Now, It is true, as Keith said, that the non-regression provision is subject to the famous or infamous trade effect condition requirement. And there are those that look at that requirement as being quite, so potentially limiting the value and the role of the non-regression clause, particularly because it has been interpreted once in the context of the Central American FTA in a dispute brought by the United States, which the United States lost in part, in fact, in great part, because the tribunal has interpreted that requirement, the trade effect, in a rather narrow, and I argue, unprincipled manner. In the paper, I put forward a different interpretation, a slightly different, that one that focuses not just on actual trade effect, but also on potential trade effect, which has the potential to expand the scope of the non-regression clause. Now, on a different front, the non-regression clause has, for the first time, excluded the requirement there need to be several instances of regression in order for the clause to be activated, so to speak. And this is novel from the EU side and the UK. I haven't seen it before. This means that in a single event of regression is enough to potentially breach the clause. Now, when we move to the commitment to implement multilateral labor standards, Keith has mentioned there several implications, Article 399. And I want to emphasize that compared to past practice, there's a reference in there also to the European Social Charter, as Keith has mentioned. Usually the references are there, at least from the EU trade practice, to core labor standards, ILO conventions, but not the Social Charter, which again expands the scope of the commitment. And it's true, I emphasize what Keith has mentioned, that contrary to the non-regression clause, the commitment to implement multilateral labor standards is not subject to the trade effect condition. I'll come to, at the end, to this point again. Now, if we move to the enforcement mechanisms, this is, again, it's pretty standard approach in the sense that there is an institutional structure, various intergovernmental committees, the Trade Specialized Committee, but there's also a formal role for civil society, the Civil Society Forum, which is the intergovernmental, supranational, international level. And then each party has sort of, has established domestic advisory groups that are supposed to be representative of various interest stakeholders. Now, ultimately, the enforcement dispute settlement mechanism is in the hands of the contracting parties. I mean, that is still something that is a feature across all the different trade agreements that do this. Now, the particularity of trade agreements in this sense is that they do envisage a special dispute settlement system, which is different from the system, the dispute settlement system provided for the entirety of the trade agreement. And so crucially, there is a consultation stage, there is a panel of experts, a more adjudicatory phase, but crucially, the decision of the panel of experts, unlike the decision of the arbitral tribunal in the case of a general dispute settlement system in the TCA, is not binding. So this has been sort of often criticized, that makes that decision in event sort of weaker. So in a sense, it is the only, if a breach has been found, by a panel of experts, the only solution is that the contracting parties find a solution, an amicable solution, and clearly the losing party agrees to comply with the decision. Now, the difference with regard to the past trade agreement practice is that for the first time, temporary remedies, which include trade sanctions, are available for the party, the complaining party, in the case the losing party is not adhering to the decision of the panel of experts. Now, the temporary remedies are only available with regard to the non-regression clause. It does not include, or it's not available, those remedies are not available in the case of a breach of a commitment to implement multilateral labor standards. But I guess it's a step in the right direction. In terms of enforcement monitoring mechanism, it's a little bit different, but another novelty of the TCA is the famous, again, infamous rebalancing mechanism, which is supposed to deal with cases of substantial divergences, including divergences in labor laws, that have a material impact on trade and investment. Now, the language will be critical, also because the TCA refers to rebalancing measures, but doesn't really specify what kind of measures those rebalancing measures may entail. There is a question which I raise in the report. The way that the rebalancing mechanism is drafted, is worded, it's not clear, or at least it leaves open the possibility that the mechanism may be also be used not only by the contracting party that claims the other party has somehow not kept up with the kind of, say, labor protections that the party has instead increased, but it could also be used as a rebalancing mechanism for the party that has not increased its labor protection. I mean, I'm not quite sure. I mean, I have to say that this may only be theoretical. I have to say I was surprised by reading the provision and thinking that this had not been clarified up front, because everybody, at least I included, saw the rebalancing mechanism as the sort of compromise to those that had demanded, the so-called dynamic alignment, and this was some sort of compromise position between the two contracting parties. Now, I have to say that although a textual interpretation is perhaps possible, I think such interpretation would go against the principles of the level playing field chapter, which in fact expressly says to maintain and improve the parties' respective high standards in the areas covered by this title. So I would think that interpreting the rebalancing mechanism in a reciprocal way, allowing the party that does not increase its standards as a way to rebalance a potential impact would go against the object and purpose of the treaty and should be discarded. Now, to sort of the final point, perhaps the options that should be considered when in fact, maybe that's a discussion that we should start having already, how to improve the TCA. I mentioned the question about trade effect. Of course, one possibility is to clarify that requirement in the same or along the same ways as the USMCA has done. rejecting the narrow view of the Guatemala panel and accepting a broader notion of trade effect. But an option is also to eliminate the requirement altogether, similarly as has been done in the context of the obligation to enforce and implement multilateral labor standards. That is certainly not, would certainly be a viable option. Now, of course, dynamic alignment, it's something that should be explored. I think particularly in the sense, having had a look at the way that the rebalancing mechanism fares in the next few years. The idea that parties should maintain equivalent standards, and if one raises its, say, labor protection, the other one should follow suit. In terms of enforcement, strengthening the dispute settlement mechanism is certainly an option. This is not a far-fetched option. For example, making the general arbitration procedure applicable in the case of all labor-related obligations and not just some. The UK-Australia FTA has gone down this route and has done that. So there are plenty of examples where that has been done already by some of the parties. And expanding the role of civil society, particularly in monitoring and enforcing labor-related obligations. Now, the option here is to thinking about formalizing some sort of certain private complaint procedures, which have sort of been contemplated and set up in various settings. For example, in the context of the rapid response mechanism, which is provided in the USMCA agreement, there is the possibility of sort of a procedure whereby a complaint is brought by any stakeholders, in fact, any national of the contracting parties. And similarly, the example of in the EU of the single entry point. It's curiously that none of these procedures are mandated by an international agreement. They're all been undertaken unilaterally by the contracting parties. So there's an option to formalize in the text of the agreement these various private complaint procedures, and also strengthening sort of the role and the initiative of stakeholders, so that the ultimate decision to activate the dispute settlement mechanism is not simply in the hands of the contracting parties, but is somewhat regulated and subject to some constraints. Now, ultimately, maybe the final word is that, I mean, I think this is, the TCA sits perfectly in sort of a trend that we've witnessed in the last 20, 30 years, whereby trade agreements have strengthened and expanded labor disciplines. It's a slow process, and I'm sure many of you find this frustratingly slow, but I think the trend is inevitable. And so I think there is, in a sense, optimism that things can be improved, and I think will be improved. Thank you.
Thank you very much, Federico, for this excellent overview of the crucial provisions in the TCA, and of course of the key points that you are developing in your excellent paper for the TUC. And speaking of the TUC, we have Rosa Crawford with us from TUC. As I said, she's been pivotal in the production and commission of this report, and she's following the Brexit trade agreements and, of course, all things Brexit very, very closely from a trade union and labor law perspective on behalf of the TUC. Rosa, the floor is yours. We are running slightly behind schedule, so yes, thank you.
Be brief. Thank you so much, Nicola. And I'd like to start by thanking ETUI on behalf of the TUC for running this event and profiling the report that we have commissioned from Professor Ortino. And I'd also really like to thank ETUC for taking part in this event today and all the TTUC support around our work on Brexit and holding UK governments to commitments on the level playing field. The TUC draws so much strength from being part of an EU-wide family, and we show together that trade unions in the UK and EU are united in our goal to protect workers' rights after Brexit. As we know, if workers' rights are lowered in the UK, it will also lead to them lowering in the EU as well, encouraging a race to the bottom, which hurts all workers. I'd also like to thank Professor Ortino for his fantastic work on this really, really valuable report, which he's presented so well here today. I'd like to just provide a little background on why the TUC commissioned this report from Professor Ortino. Now, I think everybody knows that the UK government has long talked about cutting workers' rights as a dividend or a key benefit of Brexit. They've often talked about things like the Working Time Directive or paid holiday rights as things that they would like to get rid of. And just last week, we've seen a report being issued by the UK government called The Benefits of Brexit, which outlined plans to introduce legislation to fast track the process whereby EU legislation could be reviewed and potentially repealed, which obviously puts a lot of social employment rights potentially at threat and removes a layer of democratic scrutiny and our ability to prevent that process. The report also lined up protections around data as those that the government would also potentially look to reduce, particularly looking at the GDPR regulations that's rolled over from the EU legislation. So it's clear that the government does not wish to hold or stand by these commitments it's made around workers' rights in the UK-EU trade and cooperation agreement. So it's really important for us to highlight the fact that these commitments exist and that they can be enforced. As Professor Ortino has said, there are really serious penalties if the government breaches those commitments. And with the more we highlight this in the public debate, the more it means the UK government is pushed back when it tries to come close to undermining potential commitments that it's made. I'd just like to highlight also that I think it's really important that the report makes clear that using the clauses around level playing field and the requirement that they affect trade is not as difficult to reach as potentially we first thought. I think the fact that there only needs to be a potential breach and only one instance of a breach is definitely an improvement, as Professor Ortino has said, on other trade agreements, and does mean it's more possible for us to use those clauses. Also, really importantly, is that the report shows how trade unions themselves can play a role in that process of holding the government to commitments on workers' rights in the TCA, which is really important for us to show that we have a place in this process and it isn't just between governments. Formally, trade unions can raise complaints through the Domestic Advisory Group, which is a civil society monitoring body that must involve trade unions, employers and other civil society groups. That's already been established on the EU side, as Daniele may go into, but on the UK side, we're still waiting for that to be established. It's really important it is, so we have that route. But also informally, there's lots of routes that trade unions can use through our liaison with the European Commission, EU governments, and also through members of the European Parliament. That's why I'm really pleased that we have Bernd Lange here today from the UK Coordination Group in the European Parliament. And we're really, really keen as TUC to be working with you, with the ETUC, to develop our work around holding the UK government to those level playing field commitments. And then just finally, I think the really important contribution the study makes is to flag what improvements could be made in the 2026 review that's required to take place. Professor Ortino's study outlines a number of possible improvements, and just key for us are those around eliminating that requirement that violations occur in a manner affecting trade, enabling trade unions themselves to directly launch a case if there are violations of commitments, creating that rapid response mechanism that Professor Ortino mentioned that allows for there to be penalties against individual companies, and crucially for us, requiring the UK government to keep pace with EU levels of rights, because we're seeing new rights being introduced in the EU now that will protect EU workers, but UK workers won't have those protections, such as the Work-Life Balance Directive, Transparent and Predictable Working Conditions Directive, and the Platform Workers Directive. So it's really important for us that there is a mechanism to keep us up to those levels of protections. UK workers shouldn't fall behind. Now, I know 2026 might seem like a long way away, but it's really important that we start building that work now. So I just want to conclude in saying it's really great to be with you all today, and we really hope that as TUC, working with ETUC, we can continue our work together and start building that process for 2026, as well as right now holding the UK government to those commitments that they have made. So thank you very much.
Thank you very much, Rosa. Daniele Basso, advisor on matters of trade and Brexit at ETUC. The floor is yours, Daniele.
Nicola, was just wondering whether we should maybe give the floor first to Bernd Lange. I know he's a bit more tight with the schedule, and then...
If this is fine with you, and of course with MEP Lange, the thought had crossed my mind, but thank you for suggesting this. Mr. Lange, very nice to see you. If you are happy to intervene now, that would be great.
Thanks a lot. Yeah, Daniela, thanks a lot for this opportunity. And Professor Ortino make a quite good overview about the formal possibilities for complaints inside the trade and partnership agreement. But I would just underline that there are some new elements in, specifically regarding the possibilities of setting remedies. This is the first time that the European Union and the European Commission, to be correct, accepted this possibility to set temporary remedies if a labor or environment condition is not respected and violated. Even there are some weaknesses, and Professor Antonio mentioned this as well. So in these level playing field conditions, it's linked to trade effects. So this is a really old-fashioned condition. And on the normal procedure regarding the obligations for the ILO Convention, it is just limited the remedies for the non-regression. But nevertheless, it is an element which is new in, and we as European Parliament always ask for that, to have, after this process with the intervention of civil society via the domestic advisory groups, then having government consultation, and then having this ruling of a panel of experts, to have a last resort, even using sanctions remedies to force if the ruling of the panel of experts is not accepted and fulfilled. So there is a new element in, and we should really look on that. And to use the whole set of possibilities, of course, we should really look to the strengthening of the involvement of trade unions. And perhaps you know, we have, as European Parliament, also adopted a resolution when we ratified the TCA. And this resolution has also in paragraph 11, where we really urge the specific and strong involvement of trade union in the implementation process. And we focus on 4 elements, so that we want to have specific labor forum before the Partnership Council should have their meetings, so that the specific labor issues could really transform in the discussion of the Partnership Council. And you see the whole element of the different specific rights committees, and Professor Antonio mentioned them as well. So also in some of them, specifically regarding the specific committee on regulatory cooperation, also trade union involvement has to be strengthened as well. So the second element is indeed the participation in specialized committees where relevant, and I guess the regulatory cooperation is specifically relevant. And then thirdly, we focus on the domestic advisory groups. This organization is for the European Parliament really key, and we had a lot of experience in the past. So starting with the domestic advisory groups in the agreement with South Korea, where step by step they were they get it stronger and really force at the end of the day the European Commission starting consultation with the South Korean government on the ratification of ILO convention, and at the end of the day also ruling of the panel of experts. So these possibilities of these domestic advisor groups should be strengthened as well, and we are working on that. And I guess and I hope that on the UK side, this could be also implemented soon, and really the position of trade unions on both sides of the channel can be improved with this. And the first element is the empowerment of complaints to the Commission. So we had also the experience in the past that sometimes complaints regarding violation of labor rights were not really received by the Commission. And we should really establish channels so that the trade unions are really empowered to submit complaints and really urge the Commission to act, so that we have here a mechanism that really have a proper look on the development. So this was always a clear demand from the Parliament, specifically, of course, from my political group, that we should really have a stronger involvement in the complaint process from civil society, and of course, specifically from trade unions. And we in the UK coordination group are also possibility to raise complaints, no doubt about. And in the past, we looked quite carefully in some irritations, let's say, regarding the withdrawal agreements and the Northern Ireland Protocol, and also in the implementation of the trade and partnership agreement. So don't hesitate to contact the UK coordination group as well if there are some complaints, so that we can put this on the table as well. So we are really well informed and have also the possibility to be engaged before and after each of the different specific committees and the Partnership Council as well. And then we have in the intercommittee the UK monitoring group, which is specifically regarding the implementation of the trade agreement. And I will once again invite the domestic advisory group to this monitoring group, so that they can really present the experience to the Parliament. And fourthly, we are in the process of a revision of the standard chapter for trade and sustainability in trade agreements. And as Professor Antonio mentioned, this is a development. Beginning of this century, there was more or less no TSC chapter and trade agreements, and step by step, there was a development even knowing that there are some weaknesses still. And so we want to have a revision. And now the European Commission made a public consultation, and at the end of this month, there will be the publishing of a study comparing different mechanisms, and also this UMCA rapid alert system. And based on that, we will have a new model chapter for strengthening labor rights. And this has to be incorporated, of course, in the trade and partnership agreement as well. And the revision process that was mentioned also in the study for 2026 is really important. It is totally clear that the European Parliament will not accept any agreement anymore with the old-fashioned style TSD chapter in. So we will focus for the reform in the next months, and then also to incorporate it in trade agreements. On the reform proposals, of course, I'm going ahead with the proposals. So the relation of this level playing field on the violation regarding trade and investment, I guess it's really absurd, because you can't really measure it, and the Guatemala case shows quite clear that at the end of the this effect is not really measurable, and this we have to reflect in reform of the agreement as well. But it will be not easy, because it needs a consent of both sides. And lastly, on the UMCA and this rapid alert system, by the way, it should be not a one-way street. So I discussed this with the USTR, Catherine Tai as well. So we have also some violation of labor rights in the United States. Sometimes they should look into the mechanism inside the United States, the right to work legislation as well. But nevertheless, this company orientated is a new element, and we will reflect on that. Also regarding the coming due diligence legislation, which will be valid for the UK as well. So looking more on the concrete behavior of a company is in our mind, and we will follow up to strengthen labor rights in this way as well. Thanks a lot.
Mr. Lange, thank you very much. What a dynamic perspective of something that was once described as an event, Brexit, but clearly it's not an event. It's clearly a process, and there's a lot going on. And Daniele Basso is here with us to share some of what is going on regarding Brexit at ETUC and the ETC perspective on this report. Thank you, Daniele.
Well, let me just say that in the ETUC, we welcome a lot this report. It brings a lot of clarification and I think a lot of hope. This report has also, I think, has changed my perspective on the TCA. I must admit, I was much more pessimistic on the possibility for trade unions to use the labor clause, but because I was fixed a bit too much on the trade effect. But I think this new report definitely brings a bit more hope, and it's going to be very useful for us for the future, in case we will file complaints or use this TCA to have enforcement of labor rights. And I want to say also that this TCA should be used also not on a one-way street. So I would really be happy if the British government would use the labor clause to sue the European Union. If there was the ground on that, we wouldn't be we would be very happy to be sued if there is the case. We definitely are not perfect, so I think we will have a lot of work ahead of us, and we'll definitely pick up the recommendations that are in this report to push for for a review in a few years' time. The review will be with the new commission and with the new parliament. We hope that Per Lange will still be there to help us out in changing the TCA, and we will do our best to push for these changes with the Commission and with our instruments that we have. So either bilaterally with the Commission, but also with the Domestic Advisory Group, which is the most institutionalized channel we have to raise concerns. So we will do our best to make this agreement really work for us. I think I'm not going to go into the content. So I think it has been very much well explained, and maybe just my last point will be that in our strategy to have a better enforcement and to have a solid case to put forward, we'll really need the collaboration of our affiliate in the UK, the TUC, because they know very well the situation on the ground. And for us, the partnership with the TUC will be key in any complaint that we might put in the future. So I think I'll stop here, but I'm very happy about the report. Thank you very much.
Thank you very much, Daniele. Normally we should be pausing at this stage, but I was wondering whether I could ask Mr. Lange to perhaps address one of the questions that have been sent to him personally in the chat, which is, my German is not very good, but I think he says, you know, what about the role of trade unions in checking compliance with the labor provisions in the TCA, for instance, by giving them a seat on the committee of experts? And has that happened? Is there a chance that it could happen in the future?
Yeah, the panel of experts will be decided on both sides, and then we have a neutral one on labor issues. We often go in the direction of the ILO. So let's see what is possible. I think it should be clear that interested parties should be really deeply involved, no doubt about.
Thank you very much. Thank you to all the speakers from this first panel. This has been extremely interesting. Let's take our 10-minute break now and convene at 10 past the hour. The hour depends on where you are currently located. So in 10 minutes time, see you soon. Thank you. Welcome back. Welcome back to the second part of today's event. We've had a wonderful, I would say, riveting first part with so much food for thought being shared with all of us, and we are continuing to do so thanks to the comments that Professor Tony Janowitz from the University of Bristol will offer on the reports by Federico, and also her insights on the trade agreement and on these clauses. Professor Janowitz, I should say, is eminently well placed to talk about this very important and topical matters. She's an authority on questions of labor standards in free trade agreement. Her work being regularly cited, including in the decision of the panel of experts in the EU-Korea FTA from last year that was mentioned by Mr. Lange in his presentation. So it's a real pleasure to have Tonia with us. Tonia, the floor is yours, and Keith spoke in the first part, so you have a few more minutes to share your wisdom with us. Thank you.
Oh, that's very kind, and it is a great pleasure to be here. I would also like to congratulate Professor Federico Ortino and the TUC on an excellent report. As others have said, the report really ably highlights the potential of the EU-UK Trade and Cooperation Agreement, the TCA, so that it really does stand some kind of chance of protecting workers' rights and complying with international obligations, notwithstanding those apparent limitations of the rebalancing mechanism, which are confined to weakening or reducing labour standard protections when this has an effect on trade. The report also offers us hope that following review in 2026, the TCA can actively promote that dynamic uplift in the UK that Rosa was talking about, so that the UK can keep pace with the EU's most impressive initiatives, such as the recent measures proposed by the Commission regarding access to collective bargaining for platform workers and other precarious workers under the draft directive and guidelines. And it would be so good if that was possible. In this brief comment, I thought that I might just flag how lessons could be learned from the EU-Korea FTA expert panel report, which Nicola mentioned. And that report came out a year ago in January of 2021. So to do that, I just wanted to speak to you very briefly about the EU-Korea FTA dispute. And then I wanted to identify what I think are 3 useful lessons that could be learned that might be really helpful for our construction and application of the TCA before that review comes about in 2026. So my summary of the EU-Korea dispute is really in terms of its history, the nature of the dispute, and its outcome. In terms of its history, the EU-Korea FTA was in 2011 the first new generation FTA with a Trade and Sustainable Development, or TSD chapter. Now it is what Bernd Lange just described as a very old-fashioned TSD chapter that the European Parliament and the Commission are seeking to review and revise. The chapter continued the tradition of importing core labour standards and ILO obligations into FTAs, no reference to the European Social Charter there. And it should be flagged that industrial relations in the Republic of South Korea were far from harmonious when the FTA with the EU was concluded. So in that sense, there are some parallels perhaps with the UK situation, where I guess again, industrial relations are far from harmonious. The Korean Confederation of Trade Unions, the KCTU, was very skeptical of the extent to which there was the base compliance with labour rights needed for the conclusion of that agreement. And the ITUC was reporting numerous serious violations of trade union rights. In Korea, the concerns included decertification of trade unions, huge damages claims against trade unions for taking strike action, even prison sentences for peaceful protest, which had been organized by the KCTU officials. And in the course of the application of the FTA, escalating concerns were voiced, not just by the KCTU and the ITUC, but the ETUC, the EU DAG, and the Civil Society Forum, and eventually the European Parliament. And that culminated in a European Parliament resolution that finally prompted the Commission to pursue conciliation and eventually establish the expert panel. As Federico notes in his report, the subject matter of the official dispute initiated between the EU and Korea was very limited. The right to strike wasn't even raised. And the provision of the EU-Korea FTA on which the EU relied was Article 13.4, which was not a non-regression clause, and it didn't require an effect on trade. It was a dispute focused on ILO principles concerned with freedom of association and Korea's obligation to make continued and sustained efforts towards ratifying fundamental ILO conventions. And the boon really was the late appointment of Dr. Jill Murray as the chair of this committee, and she is a prominent Australian labour lawyer and international law specialist. She produced a remarkable report, and it's just on that report that I want to draw. So the report didn't find any breach in relation to ratification obligations, although ILO core convention ratifications followed. What was interesting and problematic is that this expert panel procedure has been singularly unhelpful in securing the amendment of the Korean Trade Union and Labour Relations Act, and in particular addressing the really creative ways in which the panel used ILO standards to identify the breach of freedom of association for precarious workers who might be termed self-employed, the equivalent of the EU's platform workers, if you like. Now, what has happened subsequently is that the president of the KCTU has been arrested for organizing a peaceful rally on income inequality. A general strike has been called by the KCTU, seeking a just transition, and that was also met with force and a lack of sympathy. There's very little that we're seeing on the Korean side right now. And that does seem to suggest that a finding under an expert panel procedure that is non-binding is not going to deter a recalcitrant government that's determined to flout fundamental workers' rights. That's a problem in relation to the UK potentially at the moment. But on the EU side, perhaps ironically, we've actually seen quite a lot of action. So the Commission consolidated its endorsement of an assertive stance to enforcement of TST chapters, and that's promising actually for enforcing the TCA. Also, the proposals, the proposed platform worker directive and Commission guidelines, demonstrate that the EU is not going to be hypocritical and is going to seek to raise standards. So that's interesting. So what are the three lessons that could be drawn from the EU-Korea FTA report that are positive and useful for our purposes today? Well, I think one thing, and this links back to what Bernd Lange was saying earlier, is that civil society, trade union representation within the TCA process is really going to matter. So for a long time, it was thought that these domestic advisory groups, the DAGs, the Civil Society Forum, really diluted the voice and collective power of labour in this context. But actually, the views that come through from the KCTU are that the DAG, especially the EU DAG, was marvellous, that this is what really generated forms of political opposition and is keeping attention focused on what is happening in Korea. So that activism really pushed EU institutions to act. And as Bernd Lange said, trade unions really need entry. So I thought it was extremely worrying when I read in Federico's report that in relation to the UK DAG, in January 2022, more than a year post the TCA, TUC membership is not confirmed. And I think that does suggest that the UK TUC really needs allies. So obviously, firstly, with the ETUC, a member of the EU DAG, and that has access through that central entry point. So it's really reassuring to hear Daniela saying the TUC is looking for a solid case and input from the UK. And British unions will need to stay in touch with the UK coordination group as Bernd recommended. Secondly, allegiances probably need to be forged in the trade union movement with civil society to ensure there's representation of those engaged in precarious work, where labour exploitation is often centred and is at the UK at the moment. So we've seen that difficulty of platform worker representation and collective bargaining in the Deliveroo litigation in the UK. And we've seen some really interesting coalitions between the GMB with the App Drivers and Couriers Union and Unite with domestic workers organisations, and they offer useful models for greater inclusivity of voice. My second lesson, I suppose, is that the EU-Korea FTA is outdated in terms of content. The TCA has much richer content, and in part because it draws in the SDGs. So Keith has written a wonderful article in the King's Law Journal in which he explores the kinds of commitments to labour standards that are set out in the TCA. And he explores in particular Article 399. And that is actually really promising. And one of the things that is highlighted there is social dialogue. Another is the working conditions, including for migrant workers, set out in Article 399(6)(c). And that really does chime with express reference to Agenda 2030 and SDG Target 8.8, which relates to precarious and migrant work. So as Federico said, Title 11 is explicitly concerned with both the level playing field and sustainable development. We know from the rhetoric of levelling up in the UK at the moment that levelling up can just mean levelling down to a very low base. What we need is substantive standards. And it might be useful to try to see if we can use sustainable development in the SDGs in this way. Obviously, breach of Article 399 seems to only give rise to dispute resolution before a non-binding expert panel report. And we've already seen that in relation to EU-Korea, that wasn't so helpful. But it also could give rise to claims for temporary measures where there's an effect on trade. And I do think that working conditions of migrant workers could be regarded as part of the labour protections covered by Article 386. Because Article 386 refers explicitly to fair working conditions and employment standards, and that's linked to the non-regression clause in Article 387. So there are ways to actually think about forging these sound cases that Daniela was looking for. Obviously, to then utilize the rebalancing mechanism we have to show somehow that there is this trade effect that we've all been talking about. But a lot of my writing and work has been on the ways that migrant workers' treatment links to trade and services. And I do think it should be possible to show a trade effect here. And we also know that the British Parliament at the moment is clamping down on migrant workers' welfare and rights, and the Nationalities and Border Bill at the moment, and the House of Lords is an example of that. So there could be some scope for pushing more enforcement action here. We need to get the trade effect. And that brings me to my last lesson, and I will stop after this, I promise. So the last lesson I think we can take from this EU-Korea expert panel report is its comment on effect on trade and how that could be linked to sustainability. So I completely agree with Federico that we can revisit that test. I think he's right that we could think about it in terms of potential effect, and that one specific instance of regression could be enough to trigger breach. So I would stand with that. But I also think there's an obiter statement in the EU-Korea expert panel report where they're called on to speculate on whether they think there would have been a trade effect. And they basically say, don't be so sure that there wouldn't be a trade effect here. They say that in this scenario, you have to think about the ways in which there is dynamic interaction between economic, environmental, and social objectives when it comes to sustainable development, and that on the facts of EU-Korea, they're not prepared to say there was no trade effect. So I just think that perhaps we could be thinking about using sustainable development in that context as well, just to add to Federico's already excellent analysis and suggest that where we have got Agenda 2030 writ large within an instrument like this, we can find some use for that obiter statement by the expert panel. So I will stop at this point and hand over to discussion.
Thank you very much, Tanya. We have so many ideas flowing around. It's really wonderful. I think we're certainly ready for 2026, whatever may be thrown at us in the meantime. So this is indeed the part of the event that is dedicated to a discussion dealing with questions and answers. Before we take some questions from our audience, and we've had some very high numbers. The interest is clearly continuing. May I ask our speakers, including, of course, our main presenter, Federico, for any first reactions to this, as I said, riveting conversation and exchange that we've had so far.
I think I'm okay. I'm happy to get people participate.
So in that sense, there's a number of questions that have come up. Some are, I think, some very technical questions, including, for instance, about the vexed question of European Works Councils. I don't know if there's somebody in our audience that has done some work on this, but it's about, of course, the removal of some UK reps in some EWCs. We know it's a problem post-Brexit. And if there's any thoughts on this particular issue, there's been quite a few publications before Brexit that were alerting us to possible risks arising in the context of EWCs. But I think this is perhaps something on which we need to focus our attention, given the, by definition, transnationality of EWCs. And then there is also a question about supply chains. Of course, a very topical issue for debate, especially in the context of Europe's strategic autonomy agenda post-COVID, but also linked to Brexit and how they have been strained post-Brexit and what workers' reps could do about that. I don't know if there are any volunteers amongst our experts to address these questions. Rosa Crawford from TUC, thank you.
Yeah, thanks, Nicola, and thanks for those questions. Thanks very much for raising the issue around European Works Councils, because that's been one of our really key concerns around the fact that there are a number of companies now that have taken away the UK representatives on the European Works Councils following Brexit, in particular in the manufacturing sector. So this is something that our unions in manufacturing have been raising in particular. I know Industrial Europe has been doing a lot of great work and lobbying and raising this with the European Commission. I think this is a live dialogue, but I think there's something where we do need to continue to push, and because I think that there is a question mark in the Commission's mind as to whether this constitutes a violation of the level playing field commitments. Even if it doesn't, though, it is a kind of worrying direction of travel that companies are using Brexit as an excuse or a justification for reducing workers' representation. And you know, that is also kind of linking with the supply chain question. I mean, if it's the case that the kind of new companies that are set up or the new kind of investment that comes to the UK post Brexit is with companies that don't believe in this workers' representation and this kind of model that we have and we inherited and we really valued in terms of the European Works Councils, then that's also a worrying direction of travel. So yeah, I'd encourage you to look particularly at the work of Industrial Europe around the European Works Councils, and I don't know if there's a colleague here that might be able to post their contact detail in there, but thank you very much for flagging that issue, because that is a kind of already very visible effect, we think, of Brexit and employer behaviour of using Brexit as a reason to reduce this representation.
Thank you, Rosa. I see that Federico has raised his hand. Federico.
Yeah, on that point, unfortunately, the TCA doesn't do much in this sense. So there's a big difference. The TCA imposes obligations on states, and so a list, and so in order to the behavior of a company to become relevant is if the state doesn't react to it. So it's the classic lack of enforcement. But per se, the company's behavior is not subject to the obligation under the TCA. Now, the interesting aspect of the rapid mechanism, which we talked about, is in fact different, because that mechanism, although its scope and extent needs to be sort of applied in practice, but focuses on a specific business denial of certain specific labor rights. And so in that sense, sort of thinking, and this is something which I think Bernard Lang mentioned in as a sort of things to consider, is to see the extent to which a trade agreement, a future trade agreement, whether it's a reform of the TCA, but also from the EU perspective, would include also obligations on companies that can be activated. He mentioned the discussion around the broader discussion around due diligence. But that's, I mean, at the moment, unfortunately, the answer is no on the basis of the TCA until you certain focus on a lack of enforcement from the domestic sort of labor protection system.
Yes, Tonia.
Yes, just to reinforce that, clearly Article 386, which sets out what are relevant levels of labor and social protection, specifically talks about information and consultation rights at company level. So you would hope that this could be regarded as potentially enforceable under a non-regression clause as it stands in terms of holding states to account. But I wonder, I know that both you and Keith have written on this, Nicola, but I wonder if this might be one of those instances of mutually assured transgression where there doesn't seem to be enough incentive for the European Union to hold its member states to account, and therefore also the UK is allowed to get away with this as well.
Thank you very much, Tonia. Yes, that's an interesting perspective. There's a few more perspectives coming up in the Q&A window here, and I'll go through them and then you can choose how to address them. One pertains to Northern Ireland, which of course has a specific status because of the protocol that is being mentioned there, which also means that a separate set of rights, including labor rights and EU directives, apply to them. Are there any particular labor market issues for workers' trade unions in Northern Ireland arising from the TCA? Is there something specific that you could flag up there, presumably? Then there's a question about, okay, so Brexit was going to lead to a bonfire of rights. Has this happened? Is that in the making? Keith mentioned the Brexit Freedom Bill being in the pipeline. Perhaps there are additional thoughts and views. Then there is a question from Lionel Fulton on ILO conventions, something on which all of you have said something. What is the likelihood that the UK government will take them seriously, he says, without pressure from the EU? I think what is the likelihood that the EU will put the UK under pressure is also the second part of the question. So these are the questions so far. Or just see another one, but let's try and address these ones first, and please feel free to send questions through. Rosa, yes.
Yeah, well, maybe to kind of respond to those in the round, maybe to kind of start with Lionel's question. I think that there will need to be concerted pressure to make those commitments in the level playing field chapter real. And that's, as I say, one of the reasons why we commissioned this report from Federico, is we want to know the mechanisms to actually make them work. As Tonya said, when there are commitments on paper, but the mechanism isn't followed through with sanctions, it's much harder to get to a process where countries even follow those rules, follow those commitments, and then if there's no penalty on the other side of it, there's much less incentive for them to make the kind of changes that would be needed to address them. So that's why this event's happening, and we're wanting to work with so many people here today and so many groups, the UK and EU side, because we will need to work to build a place to put and build concerted pressure for the European Commission to bring a case against the UK government, because it is going to require that. But I think that, given the importance of the UK following these level playing field commitments to not undermine EU standards, I think that this is one of the reasons why the EU did take a different approach with the TCA as opposed to other trade agreements, and basically put a completely unique penalty mechanism in. They didn't have in any other trade agreements because they saw directly the threat of the UK undermining its standards. So I think that the Commission feels this is a different scenario to other trade agreements, and hopefully, if there's a credible case that we can build up, then they would consider taking action. We would really hope that that would be the case. And the economic incentive is also clear that they shouldn't be undercut. So I think that that would hopefully appeal to them. As for the question as to the level of rights being reduced already, I mean, what we've seen is mostly the kind of mood music and like the scene setting that might lead to rights being reduced. As I say, this benefits a Brexit paper that outlines this Brexit Freedoms Bill. It could be that this process that's introduced in the Brexit Freedoms Bill to review and repeal EU legislation is a kind of backdoor by which social employment legislation is repealed, rather than something that grabs headlines, which obviously is the most smart thing politically for the government to do, because it is trying to hold on to a lot of these industrial heartlands that would not want to see their rights being reduced. So it's also our job to kind of put this in the spotlight if it happens. But so far it's been kind of the move music around repealing EU law and around, as I say, data protection regulations, which they have been quite clear about. They say they want to regulate and do things differently, by which it's clear they mean reduce the level of protection for personal data. So those have been the kind of two big areas, but it's important to kind of keep flagging those threats, because that may lead to something that is a serious violation further down the line.
Indeed, yes. Tonya, see you've raised your hand.
I was just going to add in a few proposals that are coming through even beyond these. So I mentioned the Nationality and Borders Bill, which is talking about creating a two-pronged status for those people who would normally have been allowed entry as refugees if they enter legally. It seems that legal entrance, if we look at Priti Patel's speeches, might well be linked to employer sponsorship that's set up through camps, so that there's a employer tie-in in order to enter the UK lawfully as a refugee, and that we will end up with those who illegally enter will be allowed to stay and work, but will be a kind of secondary, cheaper workforce. It's those sorts of things. It's a movement to say a single enforcement body, when we don't know what that will involve and what resources it will have, that could mean a reduction in enforcement capacity, which could easily happen under 387, Article 387. And there's also noises around, we've been around for a long time, on reducing the right to strike, for example, in transport and railways. So I mean, I think there's quite a lot on the cards that hasn't quite hit yet, because we've been slowed down possibly by COVID and the immediate supply chain problems of Brexit. But I do think there's quite a lot to watch out for here.
Thank you, Tonya. And questions are coming in thick and fast, and I'll try to relay them.
I can pick up one.
Oh yes,
question
yes,
for me.
indeed.
I can start with that about the reference I made to
The Australian.
the Labour chapter in the UK, Australia, and basically, so the novelty in that context is that you find the similar structure where you have substantive obligations. Now, to some extent, those obligations mirror the ones you see in the TCA, but are not as extensive as those found in the TCA. For example, the non-regression clause has sort of the usual language that you need to show a practice of non-regression, not an individual act of regression. But generally you find those similar substantive obligations. But interestingly, aside from a quite elaborate consultation phase, the chapter then, if the parties still remain in dispute with regard to whether one of them is complying with the labor obligations, the chapter then references the parties to the dispute settlement system, the general dispute settlement system, which applies for the entirety of the trade agreement, which is usually, and it is in this case, leads to binding decisions and decisions that be subject to remedies such as trade sanctions. So that's the novelty of that. And again, it shouldn't be taken as a model if you want to have an expansive set of obligations, because that agreement takes us a rather narrow view on that score, but it does improve in terms of its dispute settlement mechanism.
Thank you, Federico. So there are some questions, also some comments about British reps remaining on EWCs that continue to emerge. There's a question about the possible role and contribution that the Commission Chief Enforcement Office could have in the topics that we're currently discussing. And there's also a question about the social charter. We've heard that the substantive provisions are not necessarily respected in the UK, but how about also the procedural and the complaints processes? Is there any chance that because of the TCA, additional pressure could be put internally for this to happen? Any takers? You're getting some very challenging questions. I'm glad that I'm chairing this event rather than Rosa.
I'm happy to come in. I think that's a really important point around the Chief Trade Enforcement Officer, or Chief Enforcement Officer the EU has created. That was a very welcome development for trade unions, that the Commission acknowledged there should be a central point where complaints could be submitted. The experience of Korea, where it was over 5 years from the DAG raising the complaint to actual action being taken, showed there needed to be a proper timeline and a transparent process that actually led to action. So sees the creation of the Chief Trade Enforcement Officer as being an important step towards that process. And then there is this single entry point whereby complaints can be formally submitted, and there is a set timeline by which they have to be looked at. And then if the Commission chooses to take it forward, then there is a timeline for investigations, which is all an important step forward. I think, as I understand it, I don't think that's really been tested so far. So I think that it's still a process that we need to see if it actually leads to action. But it's important that it's there. And Federico's report does flag that it is one of the avenues that TUC, through the European TUC, could bring a complaint to the single entry point. So it is an avenue that we could use as TUC and ETUC working together. So I think that is an important avenue to consider, because whilst we've got the DAG and the parties need to formally take account of what they say, there's not a set process for what happens next. So I think that single entry point does give us a kind of important avenue to use, and I think it would be important to think about how we can test that out, as it were, and hopefully lead to some actions as a result of it.
Thank you, Rosa. Any other thoughts, comments, reactions? Tonia, yes.
I mean, I could come in a little bit on the European Social Charter. I mean, I think it's very interesting that the European Convention on Human Rights seems to have been too politically sensitive to be placed squarely in this instrument. And so it is the European Social Charter. But that does raise some really interesting questions. So that point in the chat about whether this could create some kind of pressure towards, say, ratification of the Collective Complaints Protocol or the revised Social Charter, well, maybe that could be seen as appropriate forms of enforcement, especially if we got to the stage post the 2026 review that Federico was talking about, where we're looking at sort of dynamic accompaniment so that we're trying to actually meet up with European level standards. I think that any external pressure at the moment from the EU, even just noises, could be very useful internally in terms of collective bargaining, political lobbying. So, I mean, that's what we most need at the moment.
Thank you, Tonia. Federico?
I mean, it's important, unfortunately, to highlight sort of the technical legal aspects of the TCA, and I sort of we try to do that with the report. So the fact that only the non-regression provision are subject to a stricter way to enforce it through trade sanctions, where the obligations to implement effectively international labor standard is not. I want to echo what Keith said early on about, aside from this fact, one should not abandon the fact that those still remain as obligations, international obligations, even if, a potential breach may not be sort of remedy through trade sanctions, does not mean that that is not a violation of such an obligation. And so Keith referred to the rule of law, and to some extent, this is important. So I think one should be aware of the technicalities, but at the same time should not lose track of the fact that these are binding obligations, whether it's the non-regression clause or the several obligations to implement multilateral labor standards, and those should sort of be kept up and explore if there's anything that seems that either governments, as was said earlier, is in breach of those obligations. One should not restrain simply because the dispute settlement mechanism is not as strong as one would want it to be. I mean, the second point I want to make is that I'm sure that in 4 or 5 years' time, we will look at the labor chapter in the TCA and we think how old that is and how inefficient and ineffective it is. And I think, we'll find ourselves, I mean, maybe I'm being more optimistic, but I think, going back to what I said in terms of, the direction of travel that we are going, the EU will move, quite soon, and we will see that there will be additions and improvements to the current, and I'm pretty sure, whether it's this government, the next government, but the UK, I'm optimistic on that level too, that they will be willing to follow suit as well.
Thank you, Federico. We have one question that I think could be expanded as partly trying to ask us to share some thoughts on temporary migrants and perhaps seasonal migrants and the status. Antonia was alluding to the risk that migrant status could become a new pocket of precariat in the UK, employed under exploitative conditions. And I think the question is trying suggesting us whether we could elaborate a bit more on this. by reference in particular to lorry drivers, but I think it may be a broader question here. And are there any thoughts, Tonya, Rosa, Federico?
I think Rosa would like to come in and I'll follow her. Yeah.
Okay, thanks, Tonya. Yeah, I mean, for TUC, we are really concerned about the exploitative conditions under which migrant workers are being brought into the country. The fact that, as we always said, when freedom of movement ends, you are going to create a system whereby people's legal status in the country is linked to their employment contract, which fundamentally makes them insecure and at the mercy of their employer. And often the kind of sectors that people are brought in on the most insecure contracts are the ones where there is the lowest union density and where exploitative conditions are prevalent, with agriculture being one of the key examples. The government created this seasonal agricultural workers scheme that was bringing workers in on 6-month visas, and after 6 months people lose their legal status in the country. And the government's own analysis of this program has shown that it led to widespread underpayment of wages, people being paid far below the minimum wage, people living in unsanitary conditions, people facing abusive conditions at work. So the government's own report reveals that the whole design of the visa scheme was one that bred exploitation. Obviously, they will continue to use it because they are under a lot of pressure from the lobby in the food production sectors. But we are highlighting that you need to have a system whereby people can claim employment rights regardless of immigration status. Otherwise, this kind of exploitation will continue. And it's interesting in terms of the lorry drivers, those are also very short-term visas, 3-month visas are being offered for lorry drivers, also in poultry. And these are sectors where, while there have been important collective agreements in some sectors and in some employers, in road haulage recently particularly, it's no means across the whole sector, and we are concerned that those workers that are coming on short-term visas are particularly working for employers which don't have that strong collective agreements in place, and so they are more likely to be exploited. So we see this as a key front and a key issue to be raising with the European Commission around the government's commitments to actually uphold and respect those fundamental labour standards when it's revealing that there is systematic abuse against migrant workers because of the design of this post-Brexit immigration scheme. So I think that's a really important point. So thank you very much for raising it, and it's an important thing that we need to consider in this discussion.
Yeah, I was going to say something very similar to the effect that it's not as if this exploitation of migrant labor is going to be something that happens in the future. It's very much a live issue in terms of the creation of a precariat, and it's just in many ways getting bigger. So although we don't have posting of workers anymore within the construction sector because we're not part of the EU, so posting is gone officially, we still can have temporary migrant work under these particular schemes that Rosa was talking about. There's also interesting potential under GATS and also in the free movement of natural persons chapters that in free trade agreements that are being currently concluded with India and Australia. And I wouldn't understate, how problematic that is. So even Australia, in relation to the treatment of students and the continuation of their visas, has found massive levels of exploitation in terms of reports produced by Joanna Howe and others in Australia. So this is a phenomenon that we're seeing globally, and we need to be really wary of it. But the UK, looking for cheap labour at the moment and having a major labour shortage, is particularly vulnerable in terms of being seduced by exploitation of migrant labour to cure our problems temporarily.
Thank you very much. Yes, I think Susan certainly got a proper answer to this question, but the question is open and it will remain so. Could I perhaps, in an attempt to wrap up this exciting event, ask the speakers, starting with Federico, to, let's think that we are in 2024, 2025, and we need to start really gathering our thoughts and our resources in terms of lobbying for particular amendments and changes in the TCA at the earliest opportunities of 5 years from the entry into force. What would you prioritize? What would be the three main matters that you would like to see at the top of the agenda?
Well, I mean, I think one is certainly the clarification of the trade effect requirement, as I state in the report. Ideally, one should just do without it. That's certainly number one. In terms of dispute settlement, I think, yes, this distinction between labor chapter and the general trade agreement, I think it's becoming it's disappearing, at least in the context of, as we've seen with the UK, Australia, as in the US, and I think now the EU is probably coming around to it. I think the European Parliament is putting quite a lot of pressure on as we've heard from Lange, on the Commission to do that. I think perhaps the crucial aspect here is try to get civil society, trade unions included, role in the complaint mechanism. And I think ideally that role shouldn't be left to the discretion of each contracting parties. It should be somehow formalized and solidified in the context of the trade agreement. Now, it may be impossible to for the contracting parties to give away the ultimate power to control whether a formal dispute settlement is actually activated. But I think even clarifying that discretion, sort of limit the discretion, I think it would be a step in the right direction to strengthen the implementation and enforcement of labor obligations.
Thank you, Federico. Any other thoughts, ideas from our other panelists, speakers? Yeah, yes, Rosa.
I mean, yeah, absolutely. That support, and it's really important that Federico has outlined in his report the importance of those changes. I mean, for us, absolutely removing the requirement that violations occur in a manner affecting trade will definitely make it much more possible for us to bring cases. Making sure that trade unions actually themselves are part of the enforcement process and can bring cases directly will be so important for depoliticizing the process. I mean, you don't need to build the will politically on one side to bring a case against another. It can just be trade unions bring a case when rights are violated. That would be absolutely fundamentally important to us. And then that key provision around dynamic alignment and making sure that UK workers don't fall behind rights that EU workers are now receiving. And it should work both ways. As Daniele said, we would hope we would be in a position in the UK where we have a very high standard of rights, and maybe there are rights improvements in the UK that there aren't in the EU, and then the EU would also be compelled to reach the level. But it should be this race to the top, and the trade agreement should reflect that. And yet, also echoing Federico's optimism that with the TCA, we've gone places where we didn't think a trade agreement would ever go, didn't think the UK government would ever agree to any form of penalty. They wanted a CETA type unenforceable labour chapter in the trade agreement with the EU. So thinking to the future, I think it is possible to think about a much more sophisticated trade agreement that has much stronger protections in it. So I think that's why this kind of discussion is so important for helping to inform where we might be going in the future.
Tonia, yes.
I'd endorse all of that. Obviously, dynamic alignment, abolishing the trade effect, and most importantly, allowing civil society and trade unions to trigger disputes so that you can't have this kind of mutual toleration of breach. But even beyond that, I just want to make a brief plea that a lot of this rests on international and European standards relating to social and labor rights. And there's been such a lot of challenge at the International Labour Organization and across Europe recently. It strikes me that we also need to keep the origins of the rights that are imported into the TCA alive. And we're going to have to work very hard on that as well.
Thank you very much, Tonia. Thank you very much to speakers from this session and also from the previous session. A huge thanks to the interpreters that have worked really hard to make sure that we could all speak with one language, our own. And I think there's more than a meeting of minds emerging in terms of both the analysis of where we are and future prospects of where we should be going. I'm sure that this is something that we'll continue to follow in the coming months and year quite closely here at the ETUI. I'm very, very grateful to Rosa for her involvement in, of course, this event, and of course the TUC for starting this process with Federico, many other colleagues. Thank you all, and hope to see you soon. Thank you. Bye-bye.
Everyone.
Thanks all. Bye-bye.
Bye.